All right. Want to welcome everybody to the Lathrop GPM webinar, Data Privacy and Security for Franchisors. My name is Galen Knack, and I am a partner in our firm's franchise and distribution group. And I'll be joined today by three of my colleagues who are specialists in the data privacy and security area: Tedrick Hausch, Emily Wolpert, and Michael Cohen. As many of you know, franchisors currently face challenges and threats from many directions in protecting system, customer, and other proprietary data. The threats come from many directions: privacy regulators, opportunistic plaintiffs and lawyers, data privacy pirates and terrorists, as we have seen in the press, and even from franchisees. Franchisors must also determine how to apportion responsibility for data privacy compliance within the franchise system, and what role should franchisees play. While the title of this webinar speaks more generally of data privacy and security for franchisors, our data privacy and security specialists will highlight recent developments and best practices over the course of the next hour. Before turning it over to our panelists, I want to remind each of you to use the chat feature to ask questions. Time permitting, we'll address each of those questions. And if time runs short or you prefer a private response, we will follow up separately. Now I'll turn it over to Tedrick Hausch. Thank you, Tedrick.
Thank you, Galen, and welcome everyone. What I'd like to do is start by just telling you what we're going to be doing together over the next hour. And it's really three main areas. We're going to talk about data and the importance of data to the franchisor. We're going to talk about what's going on with state legislatures and legislatures across the world and the regulators who are enforcing those laws and regulations. And then finally, we're going to give you some practical tips and takeaways that you can implement as you deal with this wide-ranging and difficult subject of data privacy and data security. So the first thing that I think is a general view that franchisors must face is this delicate dance of how to deal with the data and how to do that in conjunction with the relationship they have with their franchisees. And so you're always doing a cost benefit analysis. You're looking at, what do I get from the data that we're utilizing as a franchise, and what are the risks associated with that? And of course, the most public kind of risk that you'll face is a data breach or some sort of issue where the consumer public is upset that you haven't taken care of their personal data or their personal information. But all of these things are sticks in the bundle of concerns and benefits that you have to consider. So as I said, this dance, as I view it, is how do you support your franchisees without being responsible for or owning their failures? And if you think about the franchise concept, it starts with a strong brand. And that's what a franchisor has developed and built. And in order to make that continue to grow in today's online and otherwise commercial market, you have to use data. And in utilizing that data, not only to provide analytics to what you're doing and what your franchisees are doing, it allows you to know from a marketing standpoint what your consumers are thinking and how things operationally work within your system with suppliers and efficiencies and other things that you're trying to realize. But if you, it depends on the culture of your franchise. So if you are a franchise that basically tells a franchisee everything they need to do and how to do it and where to buy it, and they come to you for basically everything, and you control all of the data, say, that even comes from the consumers at the franchisee location or portal, you're going to be likely held more responsible than, say, a franchise system that entrusts more to the franchisee, that gives it a starting point to work from, gives it the brand strength, but leaves a lot more autonomy to the franchisees. So you'll see that tension a lot in what we're talking about in a variety of ways with respect to these laws. And we've listed here on these bullet points, I won't go through them all, but there are things here that I think a franchisor must consider or think about in reflecting upon that tension. And first of all, what does your franchise agreement say? And what do your other documents say with respect to what are you requiring franchisees to do, and what are their responsibilities versus your responsibilities with respect to data? And one of the easiest ways to sort of think about this is, what does the privacy policy page, if your franchisee has a web page of their own, what does it look like? Do they just use the franchisor's template, or are they going to use their own? And if they're going to use their own, what does that privacy policy say that's different from what the franchisor says? So in other words, you have to think from both standing in the shoes of the franchisor, but also standing in the shoes of your franchisees, and think about how adept and resourceful they will be in terms of dealing with data and the issues that come from them. So really, one of the primary questions when you're thinking about this data and how to deal with it in the franchise system is, who owns it? And a lot of times in the world that we work in with respect to data, consumer data, and data privacy and data security, the word ownership doesn't usually come up, but it's necessary to think of it that way when you're talking about franchisors and franchisees. In some ways, the data subject, the individual consumer, they're the ones with the rights that they will be asserting in case of a breach or a class action if there's some sort of problem. But really, with respect to who has the ability to control that data, who hosts it, who has the ability to harvest information from it, all of that comes back to, again, the franchise agreement and other agreements. And if you think about your system, your own individual systems, are you as the franchisor able to access or download data directly from a franchisee's point of sale terminal or other computer systems? That indicates a certain amount of control that otherwise might not be in some systems. Can the franchisee use the customer data as they wish in order to promote certain items or analyze their customer base or engage in local marketing? That shows the more autonomous view of a franchise system. Loyalty programs are often among the most valuable assets that any company, much less franchisor or franchise system, will have. One thing that comes to mind for me is even 10 years ago, when Harrah's went through bankruptcy, the casino, and their larger corporation, you would think that all of those real estate properties would be the assets that contain the most value. It wasn't. It was the loyalty program that they had, because it had so much data about how people gambled. And it's likely the same with respect to a franchise in terms of that being valuable information. So for your loyalty program, who controls that data? Where is it hosted? How do you monetize it? Those are all important questions. And then finally, and we'll talk about how this is reflected here in the next slide, but what happens to data upon termination? Because not everything works out with every franchisee. So when that franchisee leaves and they want to use that data, all of these questions that you see here become important. And so this is a recent example. This was a case involving a fitness franchise, and they were based in Colorado. They had a franchisee that I think it was the first one that they were using east of the Mississippi, that was in North Carolina. And so they started off in, I think, 2019 in the fall. They made the franchise agreement. Things started to go forward, but then they started to go south near the end of 2020. And what happened was the software company that the franchisor used for maintaining all of this various data let the franchisor know, hey, this one franchisee is starting to use another software program. They're loading customer data into something else. And then it turned out, they found out that they had sent out an email using the franchisor's email address saying, hey, we're moving to a new software program. And so they effectively moved a lot of that information to a new software program while still a franchisee. And then after some more things happened. It went south and the relationship terminated. So the franchisor brought suit. And so on April 1st, the federal district court in Colorado granted a preliminary injunction. So if you think about hopefully the nightmare that you don't have to live, but if a franchise leaves and is sort of taking everything and going to a competing franchise and basically using all of your stuff, but putting it under a different flag, what are you going to do? You're going to go to court and say, Judge, they signed an agreement. This isn't fair. You need to stop this with an order. And that's what the court did on April 1st. They issued an order and said, you have to give back all of the business data that you took. You have to cease using anything that looks like their brand. Basically, you're stuck dead in the water until we figured this out. And that's what was going on. But if you see, there's a second part of this case, because a couple of months later, there was a suit to seek sanctions from the franchisee for violating the earlier order on April 1st. And what had happened there was the franchisee had taken that data and put it in a different system. It returned that data, but it also had a copy that after the termination of the franchise relationship, it put in a different app. So it had a different set of this data that they could use if necessary going forward and to communicate with the former customers of the franchisor. And the argument, once found out about this, that the franchisee made to the court was, hey, we didn't even put that data into that system until after the termination of the franchise. So it's not really the franchisor's business data. And the court said, that's baloney. I'm going to hold you liable. They had to pay, I think, half of their attorney's fees for this particular motion, which was, I think, $8,000 out of $16,000. But the franchisor was able to protect its rights. And I go into this detail just to sort of get you thinking, get the creative juices flowing in terms of how important is your data and where would you be without it. And Mike Cohen is going to talk to us about just the general idea of how this is regulated. Michael?
Yeah, thank you, Tedrick. So as you can see by this slide, we can rest assured that there are a number of data privacy laws that one could spend way too much time trying to learn the ins and outs and all the basic rights and obligations that one has. And I can promise you, we're not going to even attempt to try and get into detail on these laws. And what we thought we would focus more on today is some of the more recent developments. I mean, there's a lot been written, and you can find out whatever you need to know about some of the more specific laws that might be important to your particular franchise. You can also download a copy of this legal guide to privacy and data security. It's available from our firm website or from the Minnesota Department of Employment and Economic Development. We put this together with them. We try to update it annually each year. It's written really for non-lawyers, and it gives you kind of a snippet of just about every major data privacy law here in the US and also globally. And so I encourage you to do that. I also would appreciate if you do read this, give us some feedback. Let us know if you think there's some other areas that we should be focusing on. We try to include some practical tips as well to give you some guidance. And if you're old school and you don't like to download a copy, if you shoot me an email, we can actually send you an old-fashioned paper copy for you to look at. This is 2021. We will be updating it shortly. We do in the current guide have the CCPA covered. We don't have some of the new state laws that have gone into effect that I'll talk to you about shortly. So we're making the assumption that most of you have a basic understanding already of what the the broad landscape is relative to data privacy laws, but just to make sure we understand the basics, and that is the United States is much different than the rest of the world. We're kind of an outlier because here in the US, we still don't have a comprehensive federal privacy law. There's been hope that with the passing of the California law with that private right of action, that might be a move to further intensify efforts to pass that comprehensive federal privacy law. We have legislative initiatives each and every year. There was something called a pandemic that really slowed things down if anything was to pass. But I'm not hopeful that we're going to see anything soon, but there is no federal privacy law. But here in the US, and Emily's going to talk about that shortly, we take a sectoral approach. So depending on your industry and your franchise, you may have to deal with a federal law dealing with information provided to children under COPA. HIPAA is going to govern healthcare related data, and financial information. You've got Gramm-Leach-Bliley. So you've got those federal sectoral laws that might apply to your particular, business or the type of data that you collect. We still don't have a federal breach notification statute. That would seem like an easy thing to do. Because we don't have that, each and every time there is a data breach that may be notifiable under the terms of that state statute, you're going to have to make a determination as to whether or not notification is required by looking at the state statute of the individual whose data has been compromised. So it would really be helpful. There's no question that having a federal data breach notification statute would maybe limit the involvement of lawyers, but it would be a great thing for businesses. California has always been a trendsetter in the area of data privacy, even before the CCPA, which I'll talk to you about shortly. They were the state that was responsible for why each and every website today has that ubiquitous privacy notice that we get hired to draft sometimes and update as necessary. And I think there have been studies that show that 99% of the people don't read them. But California had the law about 10 years ago that required any commercial website operator to have a privacy notice. And as a result, privacy notices now appear in just about every website. Massachusetts, this is not as widely known, is one state that has a specific requirement that if you have data, personal information of a Massachusetts resident, you have to have what they call a written information security program. You actually have to have a fairly robust data security program in place, and it has to be in writing. We call it a WISP. And in fact, because Massachusetts has made that requirement, that's become kind of one of the standards for how written information security programs are put together by businesses. And when we do them for clients, we like to at least make sure that we're meeting the minimum standards required by Massachusetts. So this year, we have already seen at least 2 other states now that have enacted new data privacy laws. And so we are, now it's 2020 was kind of maybe a lazy year. I think we're going to see more of these laws, coming to bear. So I'm not going to spend a lot of time going into the details of the CCPA. I think most of you are probably already familiar with it now. It kind of took us by surprise. Everyone was focused on the GDPR, and it's coming. It actually was 10 years in planning. I mean, the GDPR just didn't happen overnight. And then in May 2018, the GDPR went into effect. Shortly after, we had the California Consumer Privacy Act that was spearheaded initially by Alistair McTaggart, real estate mogul. But the CCPA, while it became effective January 2020, it wasn't enforced by the Attorney General's office until July of last year. It by far is the most stringent data privacy law in the United States. And I would say, just as we have those ubiquitous privacy notices on all of our websites, it really sparked activity by businesses who wanted to make sure that they didn't give up the California economy by making sure they complied with the CCPA. And it required them to, for example, in their privacy policies, have appropriate notices to California consumers as to what rights they had. Very similar to the GDPR, in that now California consumers have rights to access deletion of their data. And it also imposes requirements on businesses to make sure that they respond to these requests in a timely fashion. One of the things that caused the CCPA to go into to be even passed was the concern that data was being sold. And so there is this requirement that if you do in fact sell personal information, you have a button on your website allowing the individual to opt out of the sale of the information. The CCPA, the definition of sale is fairly broad, so there's some questions still as to what that really means. But so the thing that is probably the most alarming for businesses relative to a new data privacy law is that this new California law includes a private right of action. It is limited. It's only in the case where a business has suffered a data breach and the business has also failed to implement data security measures. So at the top of my list when I'm talking to clients is if you are in fact within the scope of the CCPA and there are revenue thresholds, and if you are going to be collecting 50,000 or more records of it, and it's not just individuals, they include households, which is kind of an interesting expansion of the scope of a privacy law. And if you're within the scope of the CCPA, then you're going to have to make sure that you're cognizant of that. But the private right of action is one that's kind of scary. So just to bring you up to date, many of you already are familiar perhaps of what you need to do with the CCPA, but we now have been wondering, so how is this actually going to be enforced and what are we going to see relative to that? So we have now seen at least 100 actions that have been brought under this private right of action implicating the CCPA. And just 2 weeks ago, the Attorney General of California held a press conference. And I found this is really interesting, and I think it's important for those of us that are trying to see what the impact of the CCPA will be from an enforcement perspective. He noted that enforcement letters have gone out. They haven't identified who the businesses are, but the Attorney General's office actually published on their website 27 examples of enforcement actions. And so just as we look to the FTC consent decrees for some guidance, I think it's really useful to look at these examples that are published, and you'll see that what the Attorney General's office has been going after companies for, I'm going to just give you three. One is deficient privacy notices. If you don't have a listing in your privacy notice of what the rights are and how the individual can contact you to request, they're called data subject access requests, that's a problem. They've noted that to some companies, and the companies have corrected it, or they have failed to timely respond. The one thing that's important to know about the CCPA is there is a 30-day opportunity to cure. So what the Attorney General's office has said, we have sent enforcement notices out and 75% of the businesses that have received them have made changes and corrected the problem. So the next thing we need to be thinking about is California didn't stop with the CCPA, but the same individual, Alistair McTaggart, thought we really need to do more. And on the November ballot, the California voters passed the ballot initiative, and it resulted in the California Privacy Rights Act. Now, this law expands upon the CCPA. Some things it did that were good for business. It extended. There are some exemptions that were limited in the CPA for B2B transactions and coverage of employees. Those are going to be extended to January 2023. It also extended the threshold from 50,000 to 100,000. So that's good for businesses. It makes it a little bit easier to comply. They did add some new rights to data subjects. Probably the biggest thing that they did, however, is there's always been a question of enforcement. I mean, do you really have to worry about an under-resourced Attorney General's office coming after you? Well, there is now a new California Privacy Protection Agency, and this is funded by the general fund. So there is, I believe, $15 million in the hopper to allow them to hire staff. They're going to start it initially with the support staff from the Attorney General's office. But so there is going to be much more aggressive enforcement with this new agency that's going to go into effect. So that's coming around the bend in 2023.
Michael, one thing I'd add is, they start with some initial funding, but if you're thinking about money out of your pocket as a business, the California Privacy Protection Agency is probably going to be a lot like the police officer who sits in a 20-mile-per-hour zone where they can write tickets, because the more they are active and are able to write and impose fines, the more they'll be able to grow their regulatory presence. One thing also to go back to on the private cause of action for data breaches, it provides for statutory damages, which aren't particularly large. They will add up if you add up all the individuals who are involved in a breach. But what's important is you don't really get to fight about individual consumers who, as a defendant in a breach case, you would say, you really haven't suffered a harm. No one's stolen your identity. No one's charged on your charge card and on your credit card, and you haven't been able to recover it. It provides for damages without really much proof. But for your purposes, as a franchisor, there are other murky, unclear, and issues that you need to consider. And the main one, if you look through this slide, it talks about what's a business and who's going to be liable. So with the franchisor and franchisee concerns, the first one is, are you a business? That was the bullet point that Michael was talking about before. How much revenue do you have? How many individuals in California do you touch? The kind of jurisdictional prerequisites for being a business. But even if you aren't a business, you can be dragged in if one of your franchisees is a business and some other things happen. So if the franchisee is in California and doing well, and even though you're in a different state, you may be under the purview of the CCPA by virtue of that. And if you look at this second bullet point, a business is, as defined, as I said before, but then an entity that controls or is controlled by a business, and this is conjunctive, you have to have both, shares common branding with the business. And when this was drafted, this provided a lot of concern to the franchise community. You may well be aware of this, in that what is a franchise system but common branding, right? So that one seems to be pretty easily satisfied. The question is, do you control, or are you controlled by a business? And so the franchisor will be saying, am I controlling these franchisees within the means of the CCPA? And the franchisees will be saying, are we controlled? And the way they describe it in the statute is the power to exercise a controlling influence over the management. Again, not very helpful, pretty murky. And so what do we know about this? Not much. But I am concerned that the idea of control can be expanded to such a degree that almost any franchise relationship under the CCPA might be considered one where both entities, franchisor and franchisee, are businesses. And this is just an example that I have from a recent case in May. And this is not this is not dealing with CCPA or the idea of control with respect to the CCPA, because we really don't have any regulations or case law on it. But it gives you an example. This is a court that was considering a class action suit by individuals against Marriott for how they were doing their pricing and some of their fees. And the plaintiffs wanted a bunch of information about the resort fee data. And so the court said, I'm going to order the franchisor, Marriott, to provide all of this information to this class of individual plaintiffs. And these are some of the things that the court said. The court said, typical franchise agreements include an audit provision that gives the franchisor the right to access the franchisee's books and see all the information to calculate the franchisor's portion of that revenue. Well, every franchise arrangement will have some ability of the franchisor to audit or monitor or see what's going on with respect to the money. So if that's control for purposes of the CCPA, for purposes of analogy, that's problematic. Another thing the court said was the website Marriott handles, it's a central sort of type of franchise, and consumers can book rooms on both the website or at the franchisees, but they will have the ability through the way the data system is set up for the franchisor to look at this data, and therefore, since they can look at it, they can see it, they can give it to the plaintiffs in this class action suit. They have control of it for purposes of the court's consideration. And then finally, this is, to me, showing how proactive either regulators or a court might be. At the hearing, defendant contended that the franchised hotels are completely separate entities from Marriott managed hotels, and the defendant does not have control over them and cannot request the resort fee data from them. However, as explained at the hearing, the court was able to find Marriott franchise agreements through a simple online search, which contained nearly identical audit provisions. So here the court was willing to go online and look at SEC filings and the rest and say, look, I've looked at your franchise agreements and it looks like you have control. But we aren't there yet. Again, this is an analogy. There are plenty of arguments we can make against control for purposes of the CCPA, but we don't have an answer. And we've asked the California Attorney General, help us figure out what this control mechanism is. And the question was asked, does the CCPA apply to the franchisee for collecting data on behalf of the franchisor? And the answer was, we're providing general guidance, and that's a good question. And in other words, wait and see. So control is a very important concept, again, in this dance that I was talking about with respect to data.
Hey, Tedrick, I would imagine that one thing franchisors need to be mindful of is not just what the franchise agreement may state as it relates to ownership or use or access to data, but also the operations manual, because as franchisor counsel, this is a specific area where we're going to heavily rely on use of that operations manual simply because the environment is changing so fast. So we have to be mindful of not only what the franchise agreement says, but also what our operations manual may say as it relates to this control issue.
I agree. And even beyond that, if you look at the case we looked at, again, by analogy, the court went beyond even what a manual might say. It just looked at, how does your system work? What access do you have to data on your software? And so how you actually deal with the data and what you say in an operations manual, you're right, instead of a franchise agreement, will be important. So California, there's some problems there, but we're working through it, and we'll know more as we go along, but it's an area of concern. We have two, Michael, do you want to talk about these new state laws?
Sure. Again, the main purpose here is to just alert you to the fact that we've already seen now, Colorado and Virginia kind of following in the shoes of California passing new laws. Now it's interesting, they both go into effect in 2023, Colorado July 1st for some reason, and Virginia January 1st. So it looks like 2023 is looking to be a big year for everybody as far as compliance goes, because you also have the CPRA that's going into effect that same year. There are a lot of similarities between these laws and some differences. What this really does is it creates, I wouldn't say an opportunity, but you should really, as a franchisor, use data mapping as a vehicle for you to be able to look and see what you might have to do relative to your franchisor. And so the other thing that, actually keeping in the theme of trying to just give you some of the highlights of new things that have happened, I'm not sure how many of you are aware, this wasn't on a lot of people's radar, but July 19th, I believe, the Uniform Law Commission approved a new uniform law. And the uniform law is, the name of it is the Uniform Data Protection Act. You're probably familiar with the UCC that has now been adopted in just about every state. This uniform law is an effort to try to create a template that states can pass, and it's a very interesting one. It's got some GDPR features, but I'd say it's not as stringent. There is no private right of action, but certainly states could do with it what they want. But it's something that we just need to be cognizant of as more and more states are looking to follow in the shoes of now California, Colorado, and Virginia in passing their own laws, unless and until the feds come in and pass what we really should have, and that's one comprehensive data privacy law.
So we've looked at the territorial jurisdictional changes that are coming from the states, but Emily, what's going on in terms of subject matter regulation?
So a lot of times you're going to have a variety of different types of information. It can be financial, sometimes healthcare applicable, obviously not going to apply in every context. And the way that you have to treat the data as defined under this financial, for example, the Gramm-Leach-Bliley Act, is going to be different than you would be required to treat data that is covered under HIPAA or not covered under any of these sectors. And you could have a variety of different ways to have that you have to store, share, permissions you need to get, consents you need to get, and it's not going to be based on what sector you as an entity falls into, but what type of information the actual data is. Then it also, similarly, there's the different type of information that you get. So are you getting children's information? A lot of this is going to relate in the marketing sense. COPA, there's also a couple of states that have state level Children's Privacy Protection Acts, California being one of them. Relatively similar, but might have different obligations. And again, you don't have those obligations across all the information you have, but you will need to store the data of children differently than you would that of an adult, and they have different rights under that as well. I think some of the most important federal laws currently that you see a lot of issues surrounding right now are going to be the TCPA or Can-Spam Act. It's going to be regarding the marketing that you do and the types of communications you can send to your customers or potential customers. And the way those are defined are different as well. A lot of class actions in TCPA doesn't just apply to phone calls, it'll apply to the text messages you send, whether they're promotional, whether they're informational. One little issue with the TCPA is that every single act is going to be a violation. So every text message that you send is a separate violation. The issues there come with how do your franchisees obtain that information and obtain the consent, because they have to have consent in order to send it. Understanding that as a franchisor, you don't necessarily dictate obtaining that consent. but that will trickle, and they're required to obtain the right to send these text messages. A lot of states have now enacted what they may call mini TCPAs, but not really mini. They just apply only to residents of that state. Some of them are actually more robust than the TCPA itself, one of which being Florida. It's the newest one, enacted as of July 1st, or effective as of July 1st, so just now. And we're already dealing with class actions arising out of text messages sent to Florida residents, some of which date back years. And the argument that the proper consent wasn't obtained, certain signature requirements weren't obtained. And the definitions change between mini TCPA, actual TCPA, Florida TCPA, and keeping the lowest common denominator there becomes important, since you're going to have franchisees potentially in a variety of different states who may only focus on the state in which they operate, but they could have more far-reaching implications.
And in fact, our firm is representing that inaugural case, that first case in Florida. Isn't that right, Galen?
Yes, we are. And one thing to be mindful of, a lot of franchisors will use third-party vendors to help deal with consent and opt-out. Pay particular attention to those vendor agreements and responsibilities if there's a screw up in terms of handling them, because a lot of those vendors often have one-sided agreements that essentially place no responsibility on themselves. So it's important, if you are using third-party vendors, that there's at least some effort to try to get a compliance with laws provision in there, and possibly if you can negotiate some type of indemnification. It's a challenge, but if nothing else, you should be aware of it, and they should be aware of not only the federal law, but some of these growing state laws.
And I think in working with a lot of those third-party vendors, establishing a overarching opt-out list of some sort is something worth thinking about and discussing. If you have a number of franchise locations and they're not communicating with one another as to who opts out and who opts in, you could put a different franchisee, and potentially even the franchisor, could be putting themselves at risk because somebody assumed they opted out, but they really, in effect, only opted out of that one location's text messages. While that hasn't really been litigated, it is a murky territory as to who's responsible for maintaining that, and whether, who the onus is on in that case. Can spam is relatively similar. It's with emails. It's actually not as stringent in its requirements as the TCPA, but also there's certain requirements in who you're allowed to send emails to, when, what they have to contain, and that those are requirements. And while your franchisee might be sending those emails on their own behalf, if they have similar branding, or if they have your name at the top of that subject line, could cause potential bumps in the road. So dictating compliance with that within your own franchisor agreements is something worth thinking about.
And one thing I was going to interject, and I think that Michael's previously alluded to this. We don't have a federal privacy law, and when is Congress going to get 60 votes in favor of almost anything? Not very likely. But the stumbling points right now tend to be preemption, whether the federal law will preempt. So if you look at the TCPA, this whole idea of whether you allow mini acts, so would the federal data notification law preempt state laws, or just be a floor? And then do you get the private causes of action? And the FTC, as you probably know from the Wyndham case back in 2014, is fighting for more control and asserting more control under this administration over data. But those are things that are just coming down the pike. As we look at sectoral subject matter jurisdiction, though, there's one other one that isn't even government related. And do you want to talk about that just a little bit, Emily?
Yeah, so payment card industry data security standards. When you operate with collecting credit card payments, this is a standard by which you are required to comply. it's not mandated by federal government. It's not a federal law, but there are going to be requirements that you enable certain security measures, that you store credit card information a certain way, you handle it a certain way. And that is ultimately the responsibility of the franchisee, but ensuring compliance with these standards is going to be to everyone's benefit, and some sort of requirement within those agreements that the franchisee will at all times remain compliant with these standards is something worth noting, worth looking into, since they're going to be the point of sale. They're going to be the ones that are collecting this information, but how they use it and who they share it with and how they store it is going to be important to day-to-day operations for both the franchisor and the franchisee.
And the unusual thing about PCI DSS is it's its own world, right? There will be an auditor, and you're probably familiar with this. There'll be an auditor who will come and issue you a fine, depending on sort of their standards and the circumstances of the particular issue. And rarely does it get to court because they're private arbitration agreements with respect to those fines. It's kind of like being a football player in the NFL and arguing about some aspect of your uniform and how much you should be fined. And so that becomes difficult. There have been a couple of cases over the years. I think there was one where there was a $13 million fine issued against a company under PCI DSS, and they were able to knock it down to about 6. But for the most part, this is part of the world I know you're familiar with if you do online retail, but it's another example of where data is regulated and you have to pay attention to it with respect to the franchisor-franchisee relationship. I talked about the FTC. I won't spend a lot of time on it other than to say the FTC, in settling with Facebook a few years ago, they fined them $5 billion here in the US, which was the largest fine ever. And one of the things about it was that it really dug in, and in addition to the normal 20-year consent decree. So if the FTC comes after you and you're going to settle, that means a 20-year marriage with them where you're reporting to them about the measures you're taking. Those measures have gotten more specific, and with respect to Mark Zuckerberg, I think personally, they made him get officer reports independent from him that were provided to the FTC, and set up a whole apparatus so that they could monitor. In that case, it had to do with the privacy controls that were allowed to consumers. And what came right after that, you're probably familiar with Cambridge Analytica and the idea that individuals who didn't even know they were sharing all their friends' information were now need to be put in a position where Facebook communicates that. So you don't want to get involved with the FTC and have them enforce an action against you because it does mean a 20-year lifespan with them. So we've talked a little bit about the world in general, but I want to focus on this for a minute because Michael mentioned the GDPR earlier. That's the General Data Protection Regulation, which was a long time in the making and was passed on May 25th, 2018. That's when it became effective. And that was really the first impetus of all of these data privacy movements. And so that dictated or attempted to dictate for the rest of the world what privacy standards should be. So more notice, more responsiveness to consumers, all of that was placed into the hopper by the GDPR, and that's what we're seeing in California. This website that I have linked at the bottom is a map that just generally shows what the world is doing with respect to data regulation. And 66%, so 2/3 of the countries, have legislation, and the others are either working on it or thinking about it, except for very few. And so that's important to consider because in the world of online retail or dealing with customers all over the world, the resident state is usually the one that will control any complaint or claim brought on behalf of an individual data subject. So let me repeat that. We have that in the US. If there's a data breach, you have to look at all 50 states. And if you have a resident in Massachusetts, they may require one kind of notice. If you have a resident in Florida, another kind of notice. The same is true worldwide. So a resident in Ireland who's in the EU, and by the way, Ireland is now, after Brexit, the only English-speaking country left in the EU, you will have certain obligations as opposed to, say, if you were looking in Australia or you were looking in Japan. And you may well have people from all over the world with respect to a breach and who you have to notify. So So a few of these statutes, I'm just going to use as just touch points to talk about what's going on in the world. The GDPR I've already talked about. The German law, which I can't pronounce, never took German, and I don't know that I can hold my breath that long to go through that whole word. But German law is important because Germany tends to be the most aggressive enforcer of rights in the European Union. And each state, so Bavaria, for example, has its own regulators that may have its own attitude or approaches towards certain aspects of the law. And the German Supreme Court decided an important case a couple of years ago that's since been adopted by the European highest court that deals with cookies. So if you go, and you're probably familiar with this, if you go to a European website, you're going to get a cookie banner that says, will you accept all cookies, or do you want to manage the cookies? And if you go further into the cookie policy, you'll go and see that you have to select certain choices. And the way the European law works is you can't pre-check for a consumer to say agree to all marketing cookies or all tracking cookies. There are certain essential cookies you can pre-check, but most everything else you have to give the consumer the choice. So if you're programming your website and you're trying to get drive-through for sales, and you have to have consumers go through this process, it can be a nightmare if they don't just click accept all cookies. And so that's something that if you are a business that deals with consumers all worldwide, just like in California, you have to decide whether you're going to just use the California standards for the rest of the US, you are probably starting to confront with your marketing groups, do we need to just use the European cookie banner mechanism for all of our websites, whether they're in the US or not, because it gets too confusing. And because of the nature of that cookie decision and the difficulty it poses, most companies are still trying to separate the European cookie banner from what they do. But it's something that's there that you need to think about. With respect to China, just has a brand new data security law. It is government regulatory heavy, as you might imagine. And one thing I'll say about China and Russia, both have data localization laws, which say that if you're going to collect data about a Chinese resident or a Russian resident, their personal data in order to do business, that data has to remain in Russia, or it has to remain in China. Why? They say so that they can make sure you're taking the proper security measures. The reality, so they can know more about their citizens. And the Europeans take a little different approach. They really are concerned about data security standards elsewhere. And that's why they limit the transfer of data outside of the EU, unless you are a country with quote unquote adequate safeguards in place. And lo and behold, the United States, and I'm going to take you back a little bit. If you remember Edward Snowden and the PRISM and the backdoor availability and FISA courts and all of that discussion that happened in 2013, that really set the Europeans off. So they got rid of the transfer mechanism at the time was called Safe Harbor that allowed a US company to have European customers and move their data to a data center in the US. They got rid of that mechanism where you could get certified by the Department of Commerce. So that went on, and the US and Europeans came up with a new system called Privacy Shield. So if you look at the middle slide here, Privacy Shield got thrown out by the Europeans' highest court just last year. And the reason for that was that, again, they believe that US intelligence has too many rights and too much ability to get the data of European residents. And so they said, we're not going to enable this transfer mechanism. That leaves only one transfer mechanism to send EU data to the US, and those are called standard contractual clauses. And they're if you've done any of these data processing addenda, you're familiar with this long rote agreement that comes out and sets forth all of these, usually about 15 pages, and you really can't change it. It's what the Europeans have set forth, and you have to adopt it as is, and you have to agree to jurisdiction of the EU regulators in doing so. They've just issued new standard contractual clauses, but they're just more specific as opposed to anything that changes much. So that's what you need to be concerned about. The European solution, or Azure or AWS or the cloud systems, their solution has been, we'll sell you a segregated cloud. So your German resident data can be kept on a cloud in AWS, let's say, or Google Cloud, only in Germany, and it won't leave. But that still means that you have to bring to it, either through an API or otherwise, you have to bring to it your actual software to where the data sits. So there's a lot going on. I don't want to get too technical about it, but there's a lot going on with respect to this stuff. So we want to finish with just going through what do you do about this? And Michael, can you just highlight sort of some of the key points that people can, that franchisors can look at in terms of getting safer with respect to this?
Sure, I'm going to be really brief on this, but you know, the main thing I want to encourage is that you, based on what you've heard so far, is that you do implement reasonable data security. And the reason I say that, going back to that, the CCPA private right of action, and more state laws now are requiring, even the CPR, that you implement reasonable data privacy protections. The one thing we haven't talked about, there's a whole list here of things that you should be doing. We mentioned data mapping. Vendor management is key to make sure that your vendors are not accessing your systems. And also you have to downstream a lot of these obligations. If you ever get sued, one of the first things they're going to ask for under that one of those CCPA actions is provide us a copy of your information security program. It shouldn't just be ad hoc. You might have a very robust program, but you should have a written information security policy. You should also have an incident response plan. This is really basic. We do this a lot for clients. Make sure that you're prepared in the event of a data breach. Who's on the team? You should have legal, forensics, IT, all prepared. The one thing that's really important when you look at a data breach that's occurred, it may not be a notifiable data breach. So you should have an attorney who could consider what exactly happened, because these data breach notification laws vary, and it might just be an incident that does not have to be reported. Training is really important. Having tabletop exercises, training your employees. The human element is probably one of the main ways that a bad actor can get into your system, just because of lack of etiquette, common sense uses of your system, phishing exercises. So I think those are some things that are really key to having a robust data privacy and security framework. And one of the important tools is insurance. I think, Tedrick, I don't know if you have time, if you're going to still talk about insurance, cyber insurance, and the importance.
I was muted, sorry. One thing that I just want to mention with respect to ransomware, because it's everywhere, it's rampant. We know that we're really at war with respect to ransomware, but your insurance may well cover this. You have to look at your policies and vet them, but insurers are pulling back because although they'd rather spend $4 million, say, on the ransom for Colonial Pipeline than rebuilding Colonial Pipeline's entire system, the underwriting and the cost of this is getting worse and worse as we pay these criminals, mainly based in Russia. So how you set up that policy and the like is important and difficult. And there's a lot of little things to know. But the one thing that to me is interesting about this to franchisors is that ransomware as a service, which is how this works now. There's a big, there'll be a company that basically has a system for running the ransomware. They have affiliates, which are really almost like franchisees, that do the actual breaking in and they split the profits. So it's almost a franchise arrangement these days with ransomware. It's very interesting. Law enforcement may be able to learn some things from you. And then finally, we'll finish with just the takeaways. And Michael, you want to walk through these?
Yeah, I think we probably have mentioned this in a number of our presentations. Make sure that if you have a privacy, that it's accurate. The one thing we can all agree on is not very many people read them, but the FTC or a regulator will read them. And if they're not accurate and different from what you're doing, that's going to get you in trouble. As Galen had mentioned, who owns or controls the customer data in your franchise network is really important. So that should be accomplished through some form of data mapping as well that will set you up to comply with just about every law. An incident response plan, be prepared for the data breach. It's not a matter of if you will incur a data breach, it's when it will happen. Providing ongoing updates and information to your board is really important to make sure that they could ultimately be liable and at risk for any data breaches that may be under their purview. So, and it's really important to engage all levels of management in what you're doing from a privacy standpoint.
And I know we're getting near the end, and the last part is do anti-phishing exercises so that your employees know what to do. For Kansas CLE attendees, we have to put this up so that you know what you're doing. And with that, I think we've breathlessly reached the end of our hour, Deanna.
Tedrick, Michael, and Emily, I'd like to thank you for this update and expert advice. If there are additional questions, we want to let you know that you can contact any one of us. We've got the contact information here. And with that, I thank you for joining us today.